SARS is very serious about their strategic intent of making tax compliance hard and costly for those expatriates who are non-compliant.
Good morning to our listeners. This is the Tax Consulting South Africa Expatriate Tax Podcast. My name is Richan Schwellnus and I am a tax attorney at Tax Consulting South Africa. And we're joined today with my colleague and legal manager for cross-border taxation, Delano Abdoll. And we will be discussing some recent amendments and changes that SARS have published with regards to tax return filings for tax residents and tax non-residents, as well as certain declaration obligations that they must make to SARS with respect to their tax residency. This is of particular importance to South Africans that are working and residing abroad or have perhaps returned to South Africa after a period of work and residence abroad. Delano, thank you for joining us today on our podcast. In light of SARS's recent update to their webpage on seizing tax residency in South Africa for individuals, on Friday, 27 June 2025, SARS published a small amendment or change to that webpage, and at the bottom of the page they included a portion on the reinstatement of tax residency, making it quite clear that a specific date must be provided should an expat return to South Africa having previously departed. Do you have any comments or preliminary thoughts on that item?
Thank you, Richan. I think the first point is it demonstrates to me at least SARS is very serious about their strategic intent of making tax compliance hard and costly for those expatriates who are non-compliant.
Right.
What's also interesting here is that SARS's system is developing over time, and this new introduction of setting a reinstatement date becomes particularly important for expats who perhaps already are non-resident, and being aware that even when they return to South Africa, that non-residency status will have an end date. SARS now has a mechanism for which the taxpayer is obligated to inform them as to when that status ends and their residency status begins.
Interesting. And of course, with the Department of Home Affairs' recent migrant profile report, there's just under a million South Africans officially recorded as working and residing outside of South Africa. Of course, that's a significant number of South Africans that would do well to take heed of this increased scrutiny from SARS on their tax affairs.
Absolutely. I mean, we've got a very large population in South Africa. However, a very small portion of that population is actually accounted as individuals who are registered for tax.
Right.
And of that percentage, perhaps around 26%, we know that there is a minority group who are regarded as expats. In other words, individuals in South Africa registered for tax but are expatriates.
Right.
And SARS has a legislative purpose of collecting tax. So these expats are definitely on the radar, and SARS is looking to see where they can maximize compliance, collect as much tax as possible.
Spot on. Now, in your practice and your experience, would you say it's generally a trend that South Africans who have departed from South Africa and they've perhaps moved abroad to pursue alternative work and business opportunities, do they maintain a filing record? Is there an obligation for them to disclose this to SARS? Must they still file tax returns whilst they're abroad? What are you seeing in market currently?
What I'm seeing is that there's a very strong view that filing tax returns once leaving South Africa is a discretionary choice as opposed to a legal obligation.
Right.
So leaving South Africa in and of itself does not eliminate a taxpayer's obligations, which are associated with the individual being registered for tax.
Right.
It does pose the question, if I'm not registered for tax, should I register for tax when I earn my first income abroad. That's definitely a topical discussion as well. But I am seeing that there is a resistance to complying with your legal obligations to file tax returns. Now more than ever, is not only the disclosure of the correct amount of income to be taxed, but SARS is focused on the status in which that income is declared, either as a resident taxpayer or as a non-resident taxpayer.
Right. And on that note, ahead of the 2024-25 tax year's filing season, which is set to open on the 21st of July 2025, SARS also indicated there would be a slight amendment to the manner in which tax returns are filed, specifically for those expats, South African expats that are abroad, in the sense that there might be a split or a dual tax return filing required, a portion that is resident and a portion that is non-resident. Can you take us through that amendment?
So, a very interesting and again, a good point to raise. I often say that a starting point is to look at the Income Tax Act.
Right.
Section 66 and 67 become incredibly important in this particular case.
Yeah.
Section 67 deals with the registration of tax number, whereas Section 66 deals with actually filing a tax return, right? What becomes important in this amendment for expats is that during a tax year, it could be that when you cease your tax residency, a portion of that tax year needs to be disclosed and filed as a resident taxpayer in South Africa.
Right.
And following your cessation date, so the date you cease to be a tax resident up until the end of the tax year, that return needs to be declared as a non-tax resident.
Right.
Where that occurs in your first tax year as an expat that ceases residency, we view it as a split return. So one could even say that it's 2 tax years, a tax year as a resident and a tax year as a non-resident.
Right.
Depending on how long you remain a non-resident, will also dictate how many future tax returns would be filed as a non-resident. In those years, there would be no split return until you decide to return to South Africa.
Right.
Hence, the reinstatement date becomes important, because then your first portion of that tax year would be the opposite of the initial split return,
Right.
being a portion as a non-resident taxpayer, and then from the date you recommence your residency up until the end of the tax year, that then would be as a tax resident once again.
Right. Now, on that note, previously before SARS introduced these changes, what steps would an expat that was a tax non-resident, what would they typically need to do if they return to South Africa in terms of notifying SARS that they have in fact returned to South Africa and possibly recommenced or reinstated their tax residency herein?
So it might not be a popular answer for expats, but one needs to inform SARS when you leave South Africa,
Yes.
and you need to inform them when you return to South Africa. For those expats who have managed to formally obtain a notice of non-resident tax status confirmation letter from SARS,
Yes.
the letter itself has no expiry date. However, it has a built-in obligation that the taxpayer must inform SARS of any change of their registered particulars or their status, in this instance, their tax residency status,
Right.
within 21 days from when that status change occurs. This then meant that those individuals actually have another obligation to inform SARS that when they return to South Africa, their registration and amendments verification form should now be updated from a non-resident back to a normal resident taxpayer.
Right.
But previously, there was no mechanism on the form to put a reinstatement date.
Correct.
whereas in this instance there is. And interesting enough, SARS's website indicates that no supporting documents are required. This could be the beginning of a very stringent verification process that taxpayers need to be aware of, and to ensure that their narrative, which they've provided SARS to seize their residency, will align with the narrative of why they return.
No, that certainly is an important consideration for expats to keep in mind. Now, in your view, whilst currently there may be no requirement to submit supporting documents upon notifying SARS of your reinstatement of tax residency in South Africa, would you say that there is a possibility that this increased level of SARS scrutiny may be teeing up future queries or verifications from SARS into the expatriate tax affairs of a taxpayer?
I think that's a very strong possibility. I think a revenue authority would be very well equipped in assessing an expat's tax compliance on a year-to-year basis,
Right.
based on the accuracy of what is disclosed in their returns, whether it be provisional and annual returns or only their annual returns. And it means that, again, SARS, having a legislative purpose to collect revenue, needs to ensure that they collect as much tax as possible where it is legally due to them.
Right.
And a verification or audit can certainly exist where these obligations have not been fulfilled or have partially been.
Right.
So I think if you're going to be an expat and maintain your compliance in South Africa from a tax perspective, one should do it the right way and ensure that you maintain an accurate record of your tax obligations in South Africa whilst abroad.
That's very well said. Maintaining that filing history, or if you will, is certainly crucial to prevent future unexpected tax liabilities or audits being triggered from SARS. Now, would you say that this increased level of scrutiny over the expat segment of the tax base, would you say that this is perhaps connected with the SARS Billions project, where they are aiming to collect more tax to meet that budget shortfall following from the VAT hike reversal?
It could be. One important legal principle that comes to mind in this particular context is that the burden of proof rests with the taxpayer. So whatever position you want to maintain in terms of your taxes in South Africa, as the taxpayer, the burden is on you to ensure that you have the evidence, documentary particularly, or oral evidence, to support the filing position.
Right.
So neglecting the compilation of relevant documents may actually be to the detriment of a taxpayer
Right.
when the revenue authority deems that there may be non-compliance.
Right.
And having an accurate track record is more important than ever, because we are dealing with not only the revenue authority as a concept, right? We are dealing with a system. And having a tax number on an e-filing profile means that you are part of that system.
Certainly.
And for the duration of you being part of that system, from your initial year of liability, you want to ensure that the record is straight.
Right. Now, another interesting item is if we look at recent SARS statistics flowing from this year's budget speech in February and March, depending which iteration we look at, official SARS statistics say that approximately only 40,000 South African registered taxpayers have indicated to SARS that they have ceased to be a tax resident. And if we compare that figure with the almost million South Africans that are estimated to be working and residing abroad, that's a very small percentage. Do you think this increased verification and scrutiny from SARS may perhaps indicate that more South Africans might need to embark on this process to regularize their tax affairs?
It depends on the taxpayer's facts and circumstances.
Right.
There is nothing that precludes the taxpayer who is an expat abroad to maintain their status as a resident in South Africa.
Right.
And domestic laws also provide for provisions which those taxpayers can make use of if they meet the requirements to reduce their taxable income or their tax liability per year of assessment. It's also important to keep in mind that becoming a non-resident in South Africa, being a formal process as well, is still left to the discretion of the taxpayer.
Right.
And they need to be eligible in order to request that document of non-residency from SARS.
Right.
So to your point of, if there's about 1 million expats abroad, right, that could be non-resident, does it mean that they should? I think it's a case-by-case assessment. It's important statistics to be aware of, and it can help the Revenue Authority know what percentage of expats are indeed non-resident
Right.
per their records, and do they meet the requirements? And then what number of them are not? And it's important also to keep in mind that perhaps taxpayers abroad are not aware of their obligations.
Right.
So there could also be a lack of education around what is your filing obligations whilst abroad as an expat.
Right. And based on that, it certainly appears it's not always appropriate for an expat to actually apply to SARS to seize their tax residency. But as an alternative to that, what local legislative provisions would be available to them as an alternative?
Very popular one is so-called expat exemption.
Right.
One will find this exemption in section 10102 of the Income Tax Act. However, this exemption also has its limitations.
Yeah.
So we often refer to these type of provisions as a carve-out provision
Right.
in order to reduce your liability. It's aimed more at those expats who want to protect foreign employment remuneration from a double tax exposure.
Right.
From 1 March 2020, that exemption is limited to a threshold amount of 1.25 million and per annum. And perhaps you are an expat that meets those requirements and still has a portion of your income which is unprotected from double tax.
Right.
There may be additional relief under Section 6 Quat of the Income Tax Act. And that, in more simpler terms, is seeing if you are eligible for a foreign tax credit in the
Right.
form of a deduction.
Okay. Now you've briefly alluded to certain qualifying requirements. From a high level, what are those requirements?
So if we look at the expat tax exemption specifically, the most important one, if I may, is that you need to be a tax resident.
Right.
I say that because a non-resident need not apply for an exemption which protects their foreign sourced income,
Right.
as a non-resident is only taxed on income sourced within South Africa. So again, the status of a taxpayer becomes incredibly important to navigate the Income Tax Act. and applicable provisions as to what carve-outs may they be eligible for.
Right.
The other thing is, when you render services abroad, which you seek to be exempt for receiving remuneration, this needs to be done under an employment relationship.
Right.
This is a topical one on a day-to-day basis. Some expats who are abroad, they are self-employed or independent contractors.
Right.
And when one gets into the detail of the law, our common law in South Africa does not recognize these type of roles as meeting the legal definition of an employee. So services need to be rendered, right, under an employment relationship
Right.
outside of South Africa. And being a tax resident, then you need to look at days requirement.
Right.
Being abroad, we call it colloquially the 180 60-day rule. So being abroad for a period of 180 days, of which 60 days are consecutive within any 12-month period.
Right. Interesting. Now, perhaps that may suggest why the amount of taxpayers and expats that have seized their tax residency is a lot lower than the amount of expats that are abroad, because many expats are perhaps claiming this Section 10102 expat exemption. Now, in your mind, do you have any sort of predictions or views as to what we might see coming from SARS in the market in terms of queries or verifications moving forward?
I think an interesting observation is that when there were talks around amending Section 10102 back prior to 1 March 2020, we already saw that there were proposals around amending the days requirement of 180, 60 days.
Right.
I am also seeing that a lot of expats who are particularly interested in a non-residency status are working on a rotational basis.
Interesting.
And where their income does exceed the threshold of Section 10102, it becomes very interesting to see how one navigates a non-residency status using a double tax agreement.
Right.
We could see SARS honing in on this. SARS also has the power of third-party data, including the movements of expats.
Right.
And the frequency of them returning to South Africa may mean that they will be under scrutiny to see whether they've correctly claimed the exemption under Section 10102, meeting the day's requirement, or if they are indeed eligible as rotational workers to claim DTA relief,
Right.
which needs to be proven on an annual basis.
Thank you for your valuable insights and commentary today, Delano. I certainly think that we will see a greater focus from SARS on South African expats and their movements out of South Africa and returning to South Africa moving forward. And thank you to our listeners for joining us today on our Expatriate Tax Podcast episode. If you found this helpful and beneficial and informative, please like and subscribe.